Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about tax exemptions. Cases that should have gone to the Supreme Court of Canada, but didn't. A Taoist Society purchased a number of properties that it was using for the practice of its religious and cultural activities, including a number of properties that were being used for a traditional form of martial arts. The city assessed taxes against those properties on the basis of the fact that the properties were not places of worship, but were in fact just activity spaces for members of the religion. The Taoist Society appealed, arguing that the taxation assessment was incorrect and that these were places of worship because the martial art was part of the culture surrounding the religion. The court disagreed. They sought leave to appeal to the Supreme Court of Canada, and the Supreme Court denied leave. And this case raises very important issues about how we identify what is a place of worship or what is worship in the religious context. When exemptions were created to property tax and other taxation requirements for places of worship, they were created when we understood places of worship to be the traditional Christian religion type places, traditional Judeo-Christian places of worship. And you can see in many religious societies what would qualify as a place of worship, a temple or a church, for example. But there are other types of religions. And as we grow into a more multicultural and more accepting society in Canada, we need to make sure that we're not expanding too narrow a definition of what is a place of worship to religions that we're not as familiar with. When these decisions are made by people who aren't members of the religion, who have no particular expertise in the religion itself, and then are upheld on the basis of the fact that there's no evidence that this is a part of worship, these decisions demonstrate a lack of respect for the religious culture of other individuals. And it may well be that the martial art isn't a practice of worship within that religion, but it shouldn't be something that's decided without the proper recourse to the experts in that religion, as opposed to something that's decided by a tax assessor who has an interest in making sure that people are paying taxes and in collecting taxes. And it's unfortunate the Supreme Court of Canada didn't see the way that this case actually raises bigger issues about being more inclusive in our society and more open to understanding that for many people, religious practicing is not something that is necessarily done by attending a church and listening to a sermon and singing songs of worship, but can include other forms of activity that we wouldn't recognize in a Judeo-Christian, white-dominated society. Hopefully the Supreme Court of Canada has other opportunities to see the ways in which people's religious accommodations can take place in religions that come from other cultures. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.